7 things debt collectors are not legally allowed to do. You get a phone call. Unknown number. You answer, and someone on the other end starts pressuring you about a debt. Maybe they sound aggressive. Maybe they make it feel urgent. Maybe something about the call just feels off. Here is what most people do not know. Debt collectors have strict legal limits on what they are allowed to do. And a lot of them cross those lines every single day. Welcome to Know the Law. Today we are breaking down 7 things debt collectors are not legally allowed to do under federal law. If you have ever dealt with a collector, or think you might someday, this video could save you a serious amount of stress. And maybe even money. Stay with us. Number 1. They cannot use abusive or harassing tactics. Let us start with the big picture. The Fair Debt Collection Practices Act, which we will just call the FDCPA, is the primary federal law that governs how debt collectors are allowed to behave. It was specifically created to stop abusive, unfair, and deceptive practices. This law covers third-party debt collectors. Think collection agencies, not the original company you owed money to. Under the FDCPA, collectors are flat out prohibited from harassing you. That includes repeated calls designed to annoy you, using obscene language, or making threats just to intimidate. Which actually leads us right into the next point. Number 2. They cannot make illegal threats. This one surprises a lot of people. Debt collectors are not allowed to threaten actions they have no intention of actually taking. And they cannot threaten actions they are not even legally allowed to perform. So if a collector tells you they are going to have you arrested tonight, or that your wages are being garnished starting tomorrow, but none of that is actually happening or even legally possible at that point, that is a violation. Plain and simple. Threats are a classic pressure tactic. Now you know they are also illegal. Number 3. They cannot lie to you. Debt collectors cannot make false or deceptive statements. Full stop. That covers lying about the amount you owe. It covers lying about who the creditor is. And it even covers pretending to be someone they are not. Here is a specific one that comes up more than you would think. A collector cannot falsely claim to be an attorney. Why does that matter? Because a letter or a call that appears to come from a lawyer feels a lot more threatening than one from a regular collection agency. And that fear is exactly what they are trying to create. If they are not actually an attorney, they cannot say or imply that they are. That is a direct violation of federal law. Number 4. They cannot call you outside of allowed hours. Federal law restricts when a debt collector is allowed to contact you. They can only reach out between 8 in the morning and 9 at night in your local time zone. Outside of those hours, the call is off limits. Unless you have explicitly told them another time works for you. Now here is something worth knowing. In most states, the rules are even stricter than the federal standard. Some states have tightened those calling windows further. So depending on where you live, a collector calling you at 8:05 a.m. might technically be compliant with federal law, but could still be violating your state's rules. Worth looking into based on where you are. Number 5. They cannot call you an excessive number of times. This is a newer protection and it is a good one. Under federal rules, a debt collector cannot call you more than 7 times within a 168-hour window in connection with the same debt. That is a rolling 7-day period. On top of that, if you and a collector actually have a conversation, they cannot call you again about that same debt for another 168 hours after that conversation. So they cannot harass you into submission by flooding your phone. There is a hard legal ceiling on how often they can try to reach you. And again, in most states, you may have even stronger protections on call frequency. Generally, in most states with their own debt collection laws, those limits are lower than the federal threshold. Number 6. They cannot contact your friends, family, or coworkers about your debt. This is a big one that many people do not realize. The FDCPA prohibits debt collectors from contacting third parties about your debt. So that means they cannot call your mom, your roommate, your boss, or your best friend and start talking about what you owe. The only exception is a narrow one. They are allowed to contact people in your life to try to locate you, to get your address or phone number. But even then, they cannot reveal that a debt exists. They cannot tell your coworker, "Hey, we are trying to collect a debt from your colleague." That disclosure is off limits. If a collector is gossiping about your debt to the people around you, that is a federal violation. Number 7. They cannot ignore your attorney or skip sending written notice. 2 more protections that often get overlooked. First, if you have a lawyer handling your situation, the debt collector must stop contacting you directly once they know or can easily find out your attorney's name and contact information. All communication has to go through your attorney. They cannot keep calling you just because it is easier. Second, within 120 hours of first contacting you, a collector is required to send you a written validation notice. This notice must include the amount of the debt, the name of the creditor, and information about your right to dispute the debt. They do not get to wait for you to ask. It is their obligation to send it automatically. In most states, there are additional disclosure requirements beyond what federal law requires. So the baseline is 120 hours and a specific set of information. But your state may require more. Imagine you start getting calls about an old credit card balance. The collector calls you 4 times on Monday alone. Then on Tuesday, they call your sister and mention the debt to her. On Wednesday, you get a letter but it has no information about how to dispute the debt or who the original creditor is. Every single one of those things is a violation of federal law. You would have grounds to file a complaint and potentially take legal action. Now you know the rules. Debt collectors have real legal limits, and you have real legal rights. If you found this useful, hit like and subscribe so you never miss another episode of Know the Law. Drop a comment below if you have ever had a debt collector cross the line. We read every single one. See you in the next video.